Nationality of Artificial, Moral Persons by P. Armanjan, Advocate, Professor at the Quai d'Orsay School of Law, Cairo. Application of the idea of nationality to moral persons. Can one, except figuratively and for the convenience of language, speak of the nationality of a corporation, an association, or an endowment? Nationality is a voluntary judicial relation. It implies essentially the consciousness of belonging to a collection and of being submitted to the authority that directs it. It imposes obligations, fidelity, devotion, sacrifice, which have for counterpart rights participation in the sovereignty within the limits of the territory, protection beyond its frontiers. Both can have for subjects only individuals. M. Laurent puts this idea of the question in his usual clear way: a fictitious being's a country, a nationality, and, consequently, the 1001 physical, moral, intellectual circumstances which constitute a nation. Do they exercise an influence upon fictitious persons as upon real persons? The question is nonsensical. As Procureur General Leclerc has very well said, whatever effort of the imagination may be made, it cannot be said that a fictitious being is French, English, German, or Belgian. To attribute subjection to judicial persons, says also M. Durbar, is a nonsense of a kind to create confusion. A nationality in the technical sense of the word cannot be conceded to them, but only a domicile. It might as correctly be spoken of the nationality of all the generative facts of law, such as a will executed in a certain country or a sale concluded in substance and form according to the terms of a certain law. Once completed, have not these acts everywhere themselves, conformably to the law that governs them, a value of their own? A kind of existence independent of the testator or the contracting parties? In a word, a nationality. Without doubt, it is often important to determine the law by which a certain corporation is governed, the jurisdiction that takes cognizance of it, the taxes levied upon it. It will then be dealt with from these different points of view as domestic or foreign, but it must be well understood that these are simply modes of speech. The words nationality, personal statute of an association, of a corporation, or of an endowment designate simply the law by whose terms are governed in principle the formation, the consequences, the dissolution of these artificial persons. It would be better to reserve these expressions for real persons, at least it would be fitting to apply them to things or rights only with circumspection, brevitas causa, without taking them literally and only to avoid circumlocution. These objections are not destitute of a certain propriety. From all points of view, beginning by that which occupies us, it is necessary to beware of completely assimilating artificial persons and physical persons. At least the nationality of some is not established as that of others and produces results that are not identical. Is it to be said that current language is wrong in using the same expression in the two cases, and must it be reproved for confounding one word with another? This would be a purism as rigid as inconvenient. Happily, whatever M. Durbar may say of it, judicial science has no such exigencies. The definition that it gives of nationality proves that the essential conditions of this notion are realized by the association, the corporation, or the endowment as by the individual. Judicially, nationality is only the fact of dependence on a sovereignty. Every subject can endorse to be attached to one of the states among which the civilized world is divided, in order to be directed and protected by it, not only upon the portion of the territory subject to this state, but beyond its limits. This relation implies no other quality than that of subject of laws. The condition of a conscious will is in no way essential to it. The minor child and the lunatic, indeed, participate in it. If this superfluous condition is not realized by imaginary beings, the necessary and essential quality of subject of laws belongs to them without dispute. In legislation, or at least the judicial practice of all countries, corporations, at least commercial corporations, endowments, often even associations, enjoy moral personality. Being persons before the law, they have as such a nationality, and consequently a personal statute. Those even among them to which the judicial personality might have been refused enjoy, necessarily, a personality in fact and represent a sum of interests distinct from those of their members or their administrators, an abstraction that it is unreasonable to compare to acquired rights capable of resulting, in terms of a foreign law, from such contract or such will executed according to this law, and which also is provided with a veritable nationality whose determination is important from numerous points of view. All the rules relative to the constitution, to the function, to the mode of business, to the capacity of this artificial being are in principle imposed by its domestic law and applicable whatever be the place where it pursues its end, to the exclusion of the local law. Such is the principal interest that this determination offers. It is not the only one. A corporation, an association, a foreign endowment, are dealt with according to the condition imposed on foreigners, especially from the point of view of competency. It is thus that Articles 14 and 15 of the French Civil Code are applicable to them. The exercise of certain rights can thus be interdicted to them as to other foreigners. There are countries where the entry of the judicial life is open to them, at least to certain ones among them, only under some conditions: decree of the government, designation by the corporation of a responsible representative, etc., to which companies or other domestic corporations are not always subjected. Negotiation in the French exchanges of personal securities relating to foreign corporations is regulated by special provisions. The taxes to which the shares and bonds of foreign corporations are subjected are not collected according to the same rules as similar taxes levied upon the shares of French joint stock companies. It is accessorily to the study of the judicial condition of foreign commercial corporations that the nationality of these corporations, basis of their condition, has been studied by the authors. Those among them who have treated this question in its ensemble, or relative to a special subject, such as bankruptcy or the fiscal system, have found it to be sufficient in establishing summarily the criterion, by the aid of which a domestic corporation can be distinguished from a foreign one. They have done this without preoccupying themselves with associations, endowments, or even civil corporations, and in inspiring themselves especially with a desire of foiling the fraud that they take great care however not to define. In what does fraud consist? Under what conditions does it exist? It is that which no one, to my knowledge, has seriously investigated. So there is the greatest uncertainty in all this matter. Numerous systems have been proposed with a view of fixing the nationality of commercial corporations. We will pass them in review and shall see that no one of them is fully satisfactory. Each of them has been imagined in respect to a particular kind of company, joint stock or co-partnership, for example, and its exclusive criterion, which already operates badly when applied to other corporations, is yet more inefficacious when the attempt is made to apply it to associations and endowments. It is fitting, then, to study the nationality of imaginary beings in itself, separated from the consequences that can proceed from it. The study will bear upon the acquiring and change of this nationality. Of these 2 points, the first is much the more important and will retain us the longer time. It is almost the only one that has occupied the expounders. Upon the consideration of what facts is the nationality of an imaginary being determined. Such is the problem. The number of true or false solutions of which it appears susceptible is not unlimited, but, on the contrary, very restricted. It is important to examine them, to criticize them, to seek out which in a general way is the better one. This done, it remains to determine what modifications and what corrections the theory adopted ought to undergo when it shall be found insufficient, in what measure it is possible to recur incidentally to such other system rejected in principle to complete or supplement it. Before passing rapidly in review the systems proposed by doctrine or adopted by jurisprudence, let us recall again that they aim only at corporations. It can even be said commercial corporations. That is why certain of them are inapplicable to associations and endowments, which at first view is not in their favor. For greater clearness I am going to present them, discuss them, and try to correct that one of them which seems to me the better one, without giving to them a meaning broader than has always been given. Let us study, then, at first the nationality of corporations. We shall seek afterwards in what measure the ideas and the solution adopted occasionally in their behalf apply to associations or endowments, and upon what point it is fitting to modify them in making this application.